Multi-generational trusts are created with a long view in mind. They are meant to preserve wealth, promote fairness, and protect families across decades. In California, these trusts often hold valuable real estate businesses and investment portfolios intended to benefit children, grandchildren, and beyond. But no matter how well a trust is drafted, it will only succeed if it is properly managed. At the center of that responsibility is the trustee. I'm Michael Hackard, and over many years working with California families in trust administration and litigation, I've seen a consistent truth. Trust disputes in multi-generational trust planning rarely begin with bad intentions. They begin when trustees fail to understand, respect, or carry out their legal duties. So today I want to explain what trustee duties really are, how accountability works under California law, and what families can do to protect their trust and their legacy. A trustee is not just a record keeper or a messenger. A trustee is a fiduciary, which means they are held to the highest standard of care recognized by law. Under the California Probate Code, trustees must act solely in the best interests of the beneficiaries, not themselves, not any branch of the family, and not under outside influence. In multi-generational trust planning, this responsibility is especially significant. Decisions made today may affect beneficiaries who have not even born yet. That requires prudence, discipline, and long-term thinking. At the core of trustee responsibility is the fiduciary duty, which includes several key obligations. First is the duty of loyalty. A trustee must never put personal interests ahead of the trust. Self-dealing, conflicts of interest, or using trust assets for personal benefit are serious violations. Second is the duty of prudence. Trustees must manage assets carefully and responsibly, following the prudent investor rule. This means diversifying investments, managing risk, and seeking reasonable returns while preserving the trust principle. Third is the duty of impartiality. In multi-generational trusts, beneficiaries often have competing interests. Some may need current income, while others rely on long-term growth. Trustees must balance these interests fairly without favoritism. Fourth is the duty of disclosure. Trustees must keep beneficiaries reasonably informed. That includes providing financial records, tax filings, and explanations of major decisions. When trustees fail in any of these duties, accountability follows. Beyond these standards, trustees also carry significant day-to-day administrative responsibilities. They must manage investments, maintain accurate records, file tax returns, and make distributions exactly as the trust requires. In California, property tax rules, including those affected by Proposition 19, can create serious consequences if handled incorrectly. A trustee's mistake in this area can increase taxes or reduce trust value for generations. One of the most common sources of trust disputes in multi-generational trust planning is perceived bias. When trustees appear to favor one child, one sibling, or one generation, trust breaks down quickly. Even if decisions are technically allowed, lack of transparency creates suspicion. To avoid this, trustees should document their reasoning, use independent valuations for major transactions, and communicate consistently with all beneficiaries. Fairness must be visible, not assumed. Transparency is one of the most powerful tools for preventing litigation. California law requires trustees to keep beneficiaries reasonably informed, yet this duty is often overlooked. Annual reports, clear explanations of investment performance, and timely responses to questions go a long way toward maintaining confidence. When beneficiaries understand what is happening and why, disputes are far less likely to escalate. Unfortunately, trustee violations do occur. Common problems include commingling trust funds with personal assets, self-dealing, neglecting investments, failing to provide accountings, or ignoring beneficiary requests. Even unintentional mistakes can have serious consequences. When misconduct occurs, beneficiaries have legal remedies. They can petition the probate court to compel an accounting, seek removal of the trustee, or recover financial losses caused by mismanagement. California courts take fiduciary breaches seriously because they undermine the very purpose of long-term trust planning. To reduce risk, many modern trusts include built-in accountability mechanisms. Trust protectors are neutral third parties who can review trustee conduct and even replace a trustee if necessary. Co-trustee arrangements balance family knowledge with professional oversight. Independent audits provide an additional layer of transparency. These safeguards are especially important in trusts designed to last for decades. Many families choose professional trustees for this reason. Professional fiduciaries bring consistency, neutrality, and regulatory compliance. They are not immune from accountability, but their systems often reduce the risk of error or favoritism. Even with professional trustees, families should define performance standards, require regular communication, and set clear compensation terms aligned with responsibility. If a trustee fails to perform, California law provides a path for removal. Beneficiaries may seek removal for breach of trust, incapacity, insolvency, hostility among co-trustees, or unreasonable delay. Courts can appoint successor trustees to restore proper administration. In multi-generational trust planning, naming multiple layers of successors helps avoid disruption. Periodic review is also essential. Even capable trustees benefit from evaluation. Laws change, assets evolve, family needs shift. Annual or biennial reviews help ensure the trustees' skills remain aligned with the trust's purpose. Beneficiaries also play a role in accountability. They have the right to information, the right to petition the court, and the right to seek trustee replacement when justified. Exercising these rights responsibly protects not only individual interests, but the entire family legacy. The most successful multi-generational trusts follow clear best practices. They define trustee expectations, encourage ongoing education, promote collaboration between legal and financial professionals, maintain detailed documentation, and prioritize transparency. They also invest in family engagement, educating younger generations about trust governance and financial responsibility prepares them to be thoughtful stewards in the future. At the end of the day, trustees are the cornerstone of every long-term trust. Their integrity, judgment, and accountability determine whether a family's legacy endures or unravels. Understanding trustee duties in multi-generational trust planning is not optional. It is essential. With proper oversight, clear communication, and responsible administration, families can protect both their wealth and their relationships for generations to come. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.